A stone's throw from justice setting the scene for Smith v. Charles Baker and Sons. Right, imagine this. You're at work just trying to get through the day when, bam, you're injured because your workplace is essentially a booby trap. Not ideal, right? It's not just a minor inconvenience, it's a life-altering event that can have serious repercussions on your health, your livelihood, and your future. That's what happened to Mr. Smith back in 1891, and his case, Smith v. Charles Baker and Sons, is a real humdinger when it comes to workplace safety. This case wasn't just about one man's injury, it was about setting a precedent for how workers should be treated and protected. Like, should you just accept the risk of a piano falling on your head if you work in a piano factory? Spoiler alert, no. The idea that workers should just accept dangerous conditions as part of the job is not only outdated, but also incredibly unfair. This case is a classic example of what happens when employers cut corners on safety. When companies prioritize profit over people, the consequences can be devastating. Workers end up paying the price for their employer's negligence. This isn't some ancient history lesson, though. The issues raised in this case are still incredibly relevant today. Workplace safety remains a critical concern, and the lessons from this case continue to inform modern labor laws and safety regulations. The principles from Smith v. Charles Baker and Sons still echo in courtrooms today, reminding everyone that worker safety isn't just a suggestion, it's the law. These principles serve as a foundation for ongoing legal battles and reforms aimed at ensuring safer working conditions for all. So, buckle up as we delve into the dramatic tale of flying stones, legal arguments, and the fight for a safer workplace. This story is not just about the past, it's a continuing saga that impacts workers everywhere, every single day. Mr. Smith's unfortunate day, when work takes a rocky turn. Mr. Smith, our unfortunate hero, was a stonemason. He wasn't just any stonemason, though. He was one of those unsung heroes who worked tirelessly to ensure the structural integrity of bridges. Not the glamorous kind who builds fancy walls. Think more along the lines of the guy who makes sure bridges don't collapse. His job was crucial, yet often overlooked. He's working for Charles Baker and Sons, a company known for, well, let's just say their safety record wasn't winning any awards. They were notorious for cutting corners and ignoring safety protocols. One day, Mr. Smith is doing his job, minding his own business, when suddenly, wham! Out of nowhere, disaster strikes. A stone being lifted by a crane above him decides to go rogue and take a nosedive. It was a freak accident, something no one could have predicted. It's like a scene out of a Wile E. Coyote cartoon, but with real-life consequences. The stone crashes down with a terrifying force. Mr. Smith gets seriously injured. His colleagues rush to his aid, but the damage is done. Not cool, Charles Baker and Sons, not cool. This incident was a stark reminder of the importance of workplace safety. The legal tug-of-war negligence versus I knew the risks. This is a classic battle in the courtroom, where the stakes are high and the arguments are intense. Now, the legal battle begins. Both sides are gearing up for a fierce fight, with each trying to outmaneuver the other. Mr. Smith sues Charles Baker and Sons for negligence. They were cutting corners on safety, and he had the broken bones to prove it. His injuries were severe, and the evidence was compelling. The company, though, they try to pull a fast one. They argue Volenti Non Fit Injuria, which is basically fancy Latin for he knew the risks of the job. They hoped this would absolve them of responsibility. Their argument was that Mr. Smith knew stones could fall, so he accepted the risk by working there. They claimed he had signed a risk acknowledgement form. It's like saying, well, you chose to be a lion tamer, what did you expect, Cuddles? The absurdity of the argument was clear to everyone. The court, thankfully, wasn't buying it. They realized that just because a job has risks doesn't mean employers get a free pass to ignore safety. Employers must still uphold their duty of care. Lessons from a landmark case: workplace safety for the win. The court ruled in favor of Mr. Smith, establishing a crucial precedent. Employers can't just say tough luck when their negligence causes injuries. They have a duty to provide a reasonably safe working environment. Volenti Non Fit Injuria, you just got served. This case was a game changer. It forced companies to start taking workplace safety seriously. No longer could they hide behind flimsy excuses while their workers risked life and limb. So the next time you're at work and you see a safety sign, remember Mr. Smith and his fight for a safer workplace. It's a right, not a privilege.